becomes the most important document at, at near the end of life. And if nothing else, to have whoever you put in charge, because you can't make those decisions anymore, have them free of guilt that this is what you wanted. They're not making these decisions. You've made that decisions and you're directing them to do these things. It can really be helpful in these situations.
What are durable powers of attorney and how do they differ from other powers of attorney? We're speaking with attorney Vinny Casiano about that on today's Ask the Lawyer. Vinny, thanks for joining us.
Always my pleasure to be with you, Molly.
So first off, what are durable powers of attorney?
Well, durable powers of attorney, the term durable is what you want to look at there, means that a person called the principal has created a power of attorney in which they name somebody to be their agent and to be authorized to take certain actions on their behalf, for their property, their assets, their money in the bank, all sorts of different things you can put into a durable power of attorney. The term durable means that the power of attorney lives beyond the principal's incapacity, right? So let's give you an example. Mom and dad, they create a power of attorney. They usually name the other spouse to be the agent. Then they name the kids underneath that. If mom or dad then becomes incapacitated, then the kids take over and they're able to then manage the assets, right? And there are different ways you can do it. You can have an immediately acting durable power of attorney. You can have a springing power of attorney, which says only if these events happen. Doctor says I can't understand my finances. You can also have one that says right now it's springing, but I reserve the right to sign a piece of paper that says I want to give it up. I want to actually activate or put this into effect. And then you can do it that way as well.
So can you talk a little bit about the main types of powers of attorney in California?
Sure. There's a uniform statutory power of attorney, which is a power of attorney that is delineated right in our probate code. It has a whole bunch of different requirements, and those are valuable to use because those, if somebody doesn't accept it and you've created a uniform statutory power of attorney, then you can get attorney's fees and costs to force a third party to accept that if certain conditions have been met. Right? And there are some really simple ones that are literally 2 pages long that basically say, A through N, I want all the powers N, and there's a whole assortment of powers that you have, right? And then the person just signs it, boom. Does it take effect? It takes effect immediately unless you state otherwise, right? But there are all sorts of, I have to say this, Molly, there are all sorts of provisions that you would think by reading just a simple uniform statutory power of attorney that the person you appoint to be your agent can do anything you want. In fact, there's some language in it that says that my agent can do anything in my stead, but they really can't. You see, our probate code says, well, even though we said that, the general authority granted in a power of attorney doesn't mean they can do X, Y, and Z. And a lot of times, those are the things that you really want the people to be able to do when you become incapacitated, to engage in long-term care planning, in estate planning, in tax planning at the end of your life. And if you don't have that in there because you went and got, a power of attorney online or something, and you had no idea, and you just thought it would allow you to do everything, well, you're kind of, the ship has sailed, and it's you can't do anything at that point.
So why might somebody want just a limited power of attorney as compared to the other ones? What are limited powers of attorney used for?
Sure. You know what? And I've drafted, several dozen of them. Give you a great example, right? Military family, husband or wife is in the military. They're going to be leaving overseas. They're being deployed, and they're in the process of selling a house. They can give a limited power of attorney to their spouse to engage in that transaction to sell the property, right? So that signature of the spouse that's deployed is not needed. There you go. Bam. Right. That's commonly used, for real estate transactions. It can be done for business transactions as well. Right. You're giving out a limited power of attorney for somebody to sign in your capacity, as a managing partner, as an owner, as a sole proprietor, whatever it may be in there that allows that person to sign on your behalf.
So what about a medical power of attorney? If someone grants a medical power of attorney, what does this mean the agent can do? And what about end of life care? What decisions do they have?
Wow, that's a huge chunk there, Molly. So let's understand this because I see this on the internet and people utilize these terms, right? In California, right? While there years ago there used to be medical powers of attorney, what we have now is called an advanced healthcare directive. And an advanced healthcare directive is basically a medical power of attorney where you're nominating somebody to be in charge, to basically make healthcare decisions for you. You are also incorporating into that document directives on what to do, as far as end of life decisions make, as far as, the different things, that go on, long-term care, right? Quality of life decisions. When I first started practicing, I'll be honest with you, I had the statutory form and I used to spend about 5 or 10 minutes with my clients. Oh, pull the plug if I'm in a coma, right? Blah, 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 blah. If I'm going to die, let me die, right? That kind of stuff. Now, to be honest with you, I spend 30 minutes, sometimes longer, going over all the options that I think are important to incorporate into an advanced healthcare directive, because it comes, it becomes the most important document at near the end of life. And if nothing else, to have whoever you put in charge, because you can't make those decisions anymore, have them free of guilt that this is what you wanted. They're not making these decisions. You've made that decisions and you're directing them to do these things. It can really be helpful in these situations.
So what about general or durable powers of attorney? What are they used for, and can they be changed once they're implemented?
Sure. Well, again, a durable power of attorney is just the term that's used that says this power of attorney is going to survive the principal's incapacity. So if the person that creates it becomes incompetent, the power of attorney is still valid. I'll tell you, every once in a while, I run across one of these powers of attorney that's not durable, usually because somebody tried to do it online and they said, oh, I don't know if I want that, right? And then, oh my God, they come to me after mom or dad or whoever it was that created it is now incompetent. And I say, well, it's no good anymore. And then they may have to go to court and get a conservatorship, which costs ridiculous amounts of money. So that's one of the issues. General power of attorney. Remember, I talked about the uniform statutory power of attorney. General power of attorney is basically a power of attorney that not a uniform statutory power of attorney, right? And those can be valuable. That like they call them attorney drafted powers of attorney. I use both on a regular basis, depending on the situation. What is appropriate. Sometimes I'll have more than one power of attorney, for clients in specific circumstances, right? So, it really depends. And this is why getting an attorney that understands this area of law and can advise you, adequately after listening to what your family circumstances are, what your objectives are, explaining what the law is, listening to what you say back. That's why you get an attorney to draft these things.
And Vinny, you touched on these websites that offer free or cheap documents, legal documents. Can you trust these?
Well, I mean, can you trust those? Are they, if you follow all the directions correctly and you understand the law, but that's it. Do you understand what the law is? Do you understand the consequences of you answering yes or no to one of these questions on these forms, right? Then, they're supposed to create valid documents. But what I will tell you is they give a false sense of security to the people that do this.
Good idea.
They absolutely do. They think that they've got documents that are going to work because of these commercials with this attractive person on TV saying, oh, we could do this. You don't need an attorney. And you know what? You want to draft it. If you want an attorney, we'll get somebody that's just out of law school that doesn't know what they're doing to answer your questions. Sorry.
Good idea to hire an experienced attorney.
Absolutely.
Vinny, thanks for joining us today.
Sure.
And that's going to do it for this episode of Ask the Lawyer. My guest has been Vinny Casiano. If you want to ask him about your situation, you can call the number on your screen. Thanks for watching. I'm Molly Hendrickson for Ask the Lawyers.